14, my lord.
Where do I?
Copy, you can give a copy. My learned friend is giving a copy.
14 and 19, my lord, two paragraphs. My lord, that summarizes the law.
And my lord, whoever has prepared the cabinet note, my lord, has relied upon this, unfortunately, forgetting that their counsel would come and dispute that by citing Nabam Rabia, which is completely irrelevant for present case. 14, your lordship gets, my lord?
Yes, I am there, sir.
As has been mentioned above, the division bench had noted this case. The division bench, however, held that even though this principle may apply to the case of chief minister, it cannot apply to a case where ministers are sought to be prosecuted. We are unable to appreciate the subtle distinction sought to be made by the division bench. The question in such cases would not be whether they would be biased. The question would be whether there is a reasonable ground for believing that there is likelihood of apparent bias. Actual bias only would lead to automatic disqualification where the decision maker is shown to have an interest in the outcome of the case. Principle of real likelihood of bias has now taken a tilt of real danger of bias and suspicion of bias. Now please come to my lord 19.
They are saying
Yes, sir.
when the cabinet is deciding about the minister or a chief minister, what will be the contours of the power of the governor?
Yes.
Where are 19, my lord?
Yes, sir.
Article 163 has been extracted above, undoubtedly in a matter of grant of sanction to prosecute. Governor is normally required to act on aid and advice of the Council of Ministers
And not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister where, as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disables itself or disentitles itself. Mr. So-and-so on behalf of ministers submitted that the case of chief minister would be completely different from the ministers. He submitted, my lord, not relevant. My lord, court says no. It applies to both, and there would be an apparent likelihood of bias if the cabinet decides, because the cabinet is appointed on the aid and advice of the chief minister by the governor. And para 32, my lord, of this judgment. On these facts and circumstances, the governor cannot act in his own discretion. There would be a complete background of rule of law, etc., etc. There was material before him, prima facie, etc. The second question, which I'll deal with, my learned friend's contention that the governor has not dealt with, parawise or otherwise, the decision taken by the cabinet notes. There are twofold answers. Answer on facts. The cabinet, the governor has taken a view that the cabinet's decision is not binding on me based upon the principle of law laid down in the 5 judges case. And therefore, there is no question for me to examine whether it is right on merits or not, because it has no jurisdiction. Second, and without prejudice to the first, there are judgments to the effect that even while acting on the aid and advice, the governor cannot sit in appeal over the decision. He is not an appellate authority who will go into the matter. I'm sorry.
Go into the merits of the case. Lord, your lordship's judgments on only police can seek approval and not that helps, that assists your lordships again, for the facts of the case. But it's a reasoned order passed on file. I'll place it on record, and whatever constitutional position, I'll assist your lordships.
All right.
I would request, any date, because once,
the governor, who is a constitutional functionary, has granted sanction, injunction of any kind, whether direct or indirect, by another constitutional body may be avoided.
The submission we have to hear and readings have to get complete. The
Yes,
submission is that the matter is tomorrow. This should not be rendered fait accompli by any action taken by the concerned court.
But unfortunately, in our legal
all.
system, nothing happens in a day in a court of law. My learned friend can,
Act on the sanction. But they can't act. that's
because, my lord, indirectly also,
We'll,
the lordships
we'll
would
post
be
it day after tomorrow or Thursday, whichever day you
Thursday, my
want.
lord, Thursday,
Thursday.
Thursday, my lord. We'll
We'll
file
post
the
it Thursday.
day after.
Let not the court proceed further till Thursday.
My lord, they can seek time, my lord. I mean, there are ways and ways, doctor.
No,
We know.
Let it not.
No, the complainants are here, but the complainants are here.
Complainants are
The
here.
lordships
my lord.
deferring the, staying the proceedings. but
I'm not-
no,
I'm
this-
not granting anything of that kind. Wait.
This is not an ego fight, but your lordship is only saying not till Thursday. It's not that well as we have
No,
to.
no, it's not an ego fight. The question of
My learned friend is
constitution.
not going to be well as part of the proceedings there.
I am not going to be.
Exactly.
Yeah.
No,
No, no, I understand. I understand, Dr. Singhvi.
AG sir.
92 to 22 proceedings till
No, that
Thursday.
I will everything I will answer. That's a different thing. AG sir, I just wanted, see, day after tomorrow, if the proceeding is there and he would proceed to pass some order, then these proceedings should not, they may not become
Infructuous.
infructuous,
I bow
why
down.
a fait
I'm not,
accompli?
I'm for a second not, my lord, either supporting or opposing, my lord, the state, because
why,
it's
sir.
for the complainant to do, but
No, because we are
Govern-
hearing the matter, hearing is whole house.
certainly, my lord, I have a suggestion to make. My lord, the governor having
No,
granted,
whatever
the
matter is tomorrow.
Lord, governor having granted sanction tomorrow, any,
No,
Ma'am, please,
see, this-
always-
Superior Court, 1 minute, yes.
ma'am, if you don't mind,
Well, I don't understand why the SG is arguing on the interim stays.
no, I'm not arguing on
That's to
interim.
explain to-
No, he fairly said that he is
I'm-
neither
I'm-
against nor for.
I'm
I-
neither
well,
against
that-
nor,
That sentiment is maintained. well.
Lord,
That is it. That's
my lord,
not, yes. sir.
principally, my lord, constitutionally, once
Yes,
the governor's sanction under challenge, based upon which some proceedings are on, my lord, another constitutional body, namely the court, would be very wary. I'm not saying there is no
And
jurisdiction.
well as the High
Say
Court, the
anything.
superior body
Only a
is
minute,
seized
Dr.
of the
Singhvi,
matter
now.
and the trial
Dr.
judge-
Singhvi, please. For
Please,
me,
sir.
it is only a matter, not even a professional matter. My lord, instead of your lordship saying, let the complainant say that both can seek time, my lord, and there is that,
I will,
can be
I will
taken care of.
appropriately balance it.
Right,
in the
That's all,
order.
my lord, I am suggesting. My lord. We are before your lordships and we would not do, my lord, I would not like anyone to do anything
Matter
which,
which is listed tomorrow before the special court.
Hmm.
But section 17A, my lord, which came to be inserted in the month of July 2018. The offences alleged are right from the year 1998, my lord. There are sequence of events which are described. Now, my lord, whether section 17A would apply to the crimes alleged to have been committed before, my lord, the insertion of section 17A is to be looked into.
Check Thursday.
So therefore, the instant proceedings, my lord, would not, my lord, affect the proceedings before the special.
So the
court.
decision is not required, is it?
No,
Whether it would apply or not?
simple submission is that.
What?
Now, my lord,
Ah.
tomorrow's proceedings, my lord, I mean, much reference is made to the
It's not
proceedings before the special court. Finally, my lord, no orders, my lord, in connection to the proceedings before the special court, pursuant to the PCR, my lord, can be passed, because the same is not in question before this honorable court, my lord. It's only the validity of the sanction order that is under
No,
question.
no. The consequence is what the learned senior counsel is saying. Try to understand. The superior court now is holding these proceedings with regard to questions to be answered by this point or to by this court.
Absolutely.
Now, at that point in time, some proceedings are taken up there, which would frustrate these, not fait accompli. Frustrate these proceedings will not be correct.
If at all, my lord, if at all, the petition, my lord, succeeds in the instant petition,
All right,
then, my lord, even then, the Sadak series case, my lord,
all
which
right.
is clearly on the point that
Ah.
when there is fabrication of documents alleged
Against whom?
against all the accused persons, my lord, against the accused number 1 to 5,
Hmm.
when there is fabrication of documents alleged,
Hmm.
certainly, my lord, the question of sanction does not arise at all. Not complying with my lord's judgment in Dr. Ashok's case, I had, my lord, as a procedural formality, I had applied to the governor. The same, my lord, does not mean that I accept the proposition that only with the aid of sanction under section 17A, I must approach the special court. Because in the instant case, the alleged offences are much prior to the date of insertion of section 17A into the Prevention of Corruption Act. Therefore, the in the Sadak series case, my lord, very clearly, my lord, Justice Oka's headed the judgment.
Hmm.
The judgment rendered by the bench,
Okay,
headed
ah.
by Justice Oka,
All right.
is clear on the point, which clearly states that when there is fabrication of documents, it is nobody's discharge of official duty. It cannot be considered as discharge of official duty. And even section 17A, my lord, it clearly reads at the end of the definition, my lord, which my lords may kindly peruse.
There is fabrication against the chief minister also.
But
Direct,
there is section
direct
120B.
question, direct answer to a direct question.
Whenever section 120B is, my lord, alleged,
Conspiracy,
please, there is conspiracy.
conspiracy.
Please,
That is all.
absolutely.
Yes.
When there is conspiracy, my lord, it cannot be said that it can be
That's
like
all.
of individualized.
That we'll see.
The act of one is the act of all.
That will see.
When there is 120.
Oh, don't say all for one and one for all here.
Please, my lord. Section 17A, my lord, if my lordship may kindly peruse.
That I have seen, sir.
Please.
Tell
Now, no police officer shall.
All right.
My lord, here.
That is after registration of crimes.
Absolutely, my lord. Now, since section 17A sanction is obtained, it would, my lord, facilitate the special judge, if at all, if he so comes to a conclusion that
We'll see.
the matter deserves referral to the police officer.
You file your objections.
Absolutely, please.
In your, yes, now this,
I appear for the,
respond number 4.
I
All
appear
all of
for-
you file your
I
objections.
appear for the respond number 5. Only Lord on the question of interim order, Lord, I thought I must bring to Lordship's notice. Hello, sir, 1 minute, I'll just cover it. 1 minute. But on the question of interim order, section 17A, but on an earlier occasion, the situation came across where the sanction was challenged. This court, Lord, division bench has taken the view that there cannot be a interim order of stay insofar as under the prevention of corruption. Well, let me point out that. Okay.
Lordships are two. This is the division bench order, which is not later on has been referred
No,
to.
this is why Justice Mukherjee or order idaದ್ಮೇಲೆ ಆಗಿದೆ.
Idaದ್ಮೇಲೆ, but subsequent, kindly see at the stage of interim order, how is that the Lordships dealt with it? First page is the prayer. May I now request Lordships to kindly see Lords, internal page 9. Internal page 9. Indeed, insofar as the grant of interim prayer is concerned, it is no doubt true that interim prayer which is sought for the writ petition is sweeping in as much as it seeks suspension of all proceedings pending disposal of the writ petition.
Indeed, the question would be whether such a request can be granted. In these regards, certain provisions of the Prevention of Corruption Act 88 is required to be looked into. Section 19 of the Act would speak about the previous sanction to be granted for prosecution with respect to public servants.
Subsection 1, Lord, their Lordships refer to subsection 2, subsection 3. One second. But kindly see in internal page 10, second paragraph. Indeed, we have not this indeed. We have not reached the stage of subsection 3C of the Act. Insofar as subclause B of section 13 is concerned, we have also not reached that stage. We are yet to see whether there is any error, omission, or irregularity in granting the sanction, which has occasioned the failure of justice. This is a question which is required to be thrashed out when the matter is heard finally.
Yes, I have seen.
Then what their Lordships refer to Satyanarayan Sharma and say 19(3) prohibits the court from considering grant of interim stay. But Satyanarayan Sharma says it also applies to the High Court. This
No,
is,
there was sanction under section 19.
no, that's true. Therefore,
Stage was after investigation and a final report being
I
ready.
request now Lordships to kindly see section 19 once again.
19, we have not yet reached that.
No, no,
stage
I'm,
at all.
the subsection 3 applies to all proceedings under that. That's what I want to
All
point.
proceedings under the Act, qua section 19.
Lord,
We are at the threshold on the 17th.
I request
day.
Lordships to kindly see 19 for a moment. 19 subsection 3.
(19)(3) subclause C. Notwithstanding, Lordships get it.
Yes, I'm there.
Notwithstanding anything contained in the Code of Criminal Procedure, C, Lordships may kindly see and
Yes.
kindly see the emphasis. No court shall stay the proceedings under this Act. But
Even
it's,
this
no, it's
court?
not core 19. No, it's
Even this court?
look, the Satyanarayan Sharma, this is exact Satyana. But now kindly go back to the judgment.
Yes, sir.
This very question was as to whether this would also apply to the High Court. And Lord Satyanarayan Sharma says at internal page 11, may I request? internal page 11 minutes, may I?
Hmm.
But however, there is a clear embargo on stay of the further proceedings. Indeed, the decision of the apex court in the case of Satyanarayana and Sharma reported in AIR so and so, wherein a similar, if not identical question fell for consideration. And the apex court was of the view that when a sanction is sought to be questioned elsewhere, the question of suspending the proceedings would not arise. The apex court has observed as, and then what the lordships refer to 482 itself.
Thus, in cases under the PC Act, there can be no stay of trials. We clarify that we are not saying that the proceedings under 482 CRPC cannot be adopted. In appropriate cases, proceedings under 482 Criminal Procedure Code is entertained. There can be no stay of trials under the Act. It is then for the party to convince the concerned court to expedite the hearing of that. This
Right.
principle,
true, sir.
yes.
There can be no comma about the principle at all. Those were cases where investigation was complete, sanction was sought for prosecution. We are at the threshold.
No, I'm
We are
not-
at the threshold where 17A is
that's
being
true.
debated
No,
upon.
I want to address your lordship's note. In
That's the
fact,
only
I
thing.
wanted to submit.
See, it is like this. Now today, this court is hearing the matter. The other court pursuant to the sanction passes some order which would frustrate the proceedings before this court. I for one will not permit.
No,
that.
for a moment, I'm not suggesting that.
Yes.
For a moment, I'm not suggesting that proceedings should result in a fait accompli to this
So
petition.
no, it won't
They have
result in
raised
fait
the-
accompli. This court, power of this court cannot, it should not frustrate the proceedings even.
In
that's
fact,
all.
they have raised certain questions of
That's
law,
what
right?
we'll
I am bound
answer
to
it.
address it.
We'll
We
answer
will
it.
file a detailed counter, lordship
Yes,
may
you
kindly
file a
consider
detailed counter, will answer all the
all
questions.
these questions.
It's a
This
question that
principle
requires